I commend the bill to the House.
I call the honourable member Claire Curran.
Thank you, Mr Speaker. Labor will support this bill to Select Committee, but we have serious reservations and concerns about it, which I'm going to outline to the House today. And despite what the Minister has just said, and going to the Select Committee we'll be able to tease these issues out, we do have a number of serious concerns. And it should be the intention of the government to have the agreement of the whole House on human rights legislation, and I think that's a very important matter to raise up front. So our support post the Select Committee will depend utterly on what we hear from the submitters. This bill, as we read it, Mr Speaker, does two things. It enables the full-time establishment of the Disability Rights Commissioner within the Human Rights Commission, and it purports to make changes to the role and structure of the Commission to, quote, strengthen its performance. And in essence, that current number of 3 full-time commissioners, i.e. the Chief Commissioner and the 2 other commissioners, and up to 5 part-time commissioners will be changed to a number of no more than 5 commissioners, including the Chief Commissioner. So formalising, our contention is that while formalising the role of the Disability Commissioner is a good thing, the rest of what the bill does or seems to do is very worrying on the face of it. And the first significant warning sign can be noted in the regulatory impact statement, which noted that, quote, consideration of complex and substantive human rights issues was outside the scope, unquote. In other words, the actual role and work of the Disability Commissioner and the position of the United Nations Convention on the Rights of People with Disabilities, or the call for a Disability Act, which some believe is required for the role of the Disability Commissioner to be effective, could not be taken into account because this bill changes the structures to be more, quote, efficient. Our fear is that in doing that, the actual work of these important commissioners will be watered down and weakened, and that's our major problem with this bill. The next warning sign came from the Human Rights Commission's media release when the bill was first introduced. And while welcoming the bill, the Chief Commissioner, David Rutherford, noted that, quote, while the proposed changes will not affect the leadership role the Commission has protecting and promoting race relations and equal employment opportunities, the Commission will need to ensure that the proposed abolition of the specific titles of these specialised commissioners does not lead to a lessening of their roles or the particular character and visibility of these human rights areas, end quote. Commenting on the increase to 4 full-time commissioners, Mr Rutherford went on to say, quote, however, as there will be fewer commissioners, those who appoint commissioners will need to ensure those in key roles reflect the diversity of New Zealand. In other words, there's a deep concern that people with generic skills and not specific skills may end up in these roles, which will affect their ability to perform their functions, and that there are issues around how they may be appointed. Mr Speaker, some disability sector groups sounded alarms at the time, including the IHC. Ethnic organisations and some minority groups also spoke up about the weakening of the Race Relations Commissioner role and the absorbing of the function within the Human Rights Commission. Because this amendment effectively removes the 3 designated specialist commissioners and their functions in preference for the ability of the Chief Human Rights Commissioner to delegate all or part of these functions to 1 or more commissioners. So we lose the race relations brand, which was the first human rights position in New Zealand and has been very well accepted by the public. So New Zealand society sought and seeks confirmation through this role, the race relations brand, that the focus will always be on positive race relations and that there's a person they can identify with to represent this focus. The same can be said about the role of the Equal Opportunities Commissioner and also the Disability Commissioner. If the problem is the relationship between these commissioners and the Chief Commissioner, then we should have no problems with the responsibility relationship of these commissioners to the Chief Commissioner to be clarified in this bill. The regulatory impact statement's articulation of the problem being addressed was to do with the inefficiency and lack of effectiveness of the part-time commissioner positions, the inflexibility of the way that the specialised commissioner roles were provided for in the Act, and the sometimes unclear and incomplete description of the functions of the Commission in the Act. But what we think that the Human Rights Commission sought, we think that that was what the Human Rights Commission sought. But in writing the amendment, we fear that the Ministry and the Minister has thrown the baby out with the bathwater. This seems to be an attempt to strengthen the hand of the Chief Commissioner by neutralising to some extent the respect that these specialist commissioners command amongst sections of the public. And the Australian High Human Rights Commission maintains specialist commissioners. Our fear is that with scrapping the individual officers, such as the Race Relations Commissioner, and the commissioners being appointed as human rights commissioners first and foremost, and then appointed a lead portfolio with a commissioner appointed to the priority areas of disability rights, equal employment opportunities and race relations, that this waters down those specialist functions. These appointments are done, will be done by the Chief Commissioner and report back to him, not to the Governor-General. The regulatory impact statement notes that a potential disadvantage of having the commissioners as human rights commissioners first and foremost is that those specialised skills, those with the specialised skills and experience in certain areas such as disability or race relations may be deterred from applying, and that only the generalist human rights experts may apply. So technically, also, this may mean that the Disability Commissioner could be a generalist, appointed to the job, could have more than one portfolio, and technically could only be working part-time as the Disability Commissioner. And if that's the case, then we do have some serious issues. Another serious concern is the potential for limiting the scope on what the commissioners can comment on. And I listened carefully to what the Minister said in her speech before, and we have a number of questions that we will want addressed in the Select Committee around this. Under the bill that's been amended in section 5(CA) in brackets to make public statements promoting an understanding of and compliance with this Act or the New Zealand Bill of Rights Act 1990. This has the potential to limit what the Human Rights Commission and its commissioners can comment on, as it removes the legislative function to, quote, make public statements in relation to any matter affecting human rights, end quote, restricting it to this Act or the New Zealand Bill of Rights 1990. So my question is, will that function of the Disability Commissioner be wide enough to tackle the important work that must be done in this area? And just to be very clear, that means what the bill says in theory means that they can only comment on matters relating to two acts rather than what has been wider in the past. For instance, I note that the United Nations Convention on the Rights of People with Disabilities isn't referenced in this bill, so potentially the Human Rights Commission and the Lead Commissioner on Disability Issues might not be able to comment on this if a narrow reading of this clause is taken.
Well, I didn't have to interrupt the Honourable Member, so thank you. Honourable Members, this debate is interrupted and set down for resumption next sitting day. The People's House stands adjourned until 2 p.m. on Tuesday, the 4th of December 2012. Haere rā, ka kite anō, good evening.